Hey, folks, James Abrenio coming to you from Abrenio Laws podcast, where we interview smart people doing interesting things. Today, I got essentially a re-interview with a good friend of mine, John Thyden, talking about property damage claims. As many of you know, when you call about your personal injury claim, your car got damaged, and so you have questions. And I decided I'll bring John on. He's my go-to guy. He knows what he's doing. He knows all the tricks in the book. So, John, first of all, thank you for coming on again today. I appreciate your time.
Thanks for having me.
And so if you could, for the people that didn't watch the first video, just reintroduce yourself. Tell us about your education, where you're from, and how you became a lawyer.
Great. Well, thanks for having me, James. As he said, my name is John Thyden, and I've been licensed for a long time. And before I was a lawyer, I was a submariner. So that sort of leads a different angle to my experiences and things like that. I started out many years ago in real property, and I decided that was not for me. And so I became a personal injury lawyer. And as things went on, I am sort of restricting my practice to automobile crashes and property damage, and a concept that some insurance carriers simply refuse to acknowledge, and that is diminished value. But it's simply child simple that if you have a fairly new car and you're in a car crash and it's repaired, that car is worth less than that identical car 1 minute before the crash. And of course, it depends upon the year, make, and model and stuff like that. If you have a 2000 Toyota, well, there's probably not too much diminished value. But I have two cases going right now. One is a Rolls Royce, and I assure you that's got maybe $10,000 or $20,000 in diminished value. I mean, that car, brand new, costs like $265,000. That's number one. Number two, the market for Rolls Royces is very discriminating. And while I've never taken a survey, I strongly suspect that many, if not most, people who are well enough off to afford a Rolls Royce would just simply take a pass on having damaged goods, as a result of which you have to, give them a fairly hefty discount for even relatively small damage because they just simply won't buy it. And I've had that confirmed by my expert, and also I've dealt directly with a Rolls-Royce dealership out in Sterling to corroborate. This was a fender bender, and the sales manager opined that the diminished value would be between $20,000 and $25,000. So this is real money, and it is applicable, I will say, in every instance. Now, sometimes it's not worthwhile economically to bring it because it simply costs to bring suit. You have the filing fees, and mostly you have our expert. So starting from zero, you have to deposit in our trust account about $500 or $600 in order to set the stage, even to permit you to file suit. Mm-hmm. But once you do, it's a fairly straightforward process. The law in Virginia is absolutely clear. There's simply no dispute that a person who harms your property is responsible for all the damages, the repair costs. By the way, substitute transportation. So if you have to either rent a car or take Uber or things like that, this is all compensable. And so that's what I do almost exclusively. Mm-hmm. And I've been doing it for a while. For those people who it matters, my Virginia State Bar number has 4 digits, which means I've been in practice for a long time.
Yeah, and yes, I appreciate that. Now, you sort of touched on it, but for the average person that's involved in a car accident, when would you suggest they call you if they've suffered damage to their vehicle? Is it everybody? Is there a subset of people? What would you recommend just the average person involved in a car accident do if they've got a property damage claim?
I would say everybody. I guess you could say I'm free with my time, and it doesn't take me but 5 minutes in conversation with the prospective client to say, I don't think you have much of a case, or, that's a really good case, and you ought to seriously consider pursuing it.
Mhm.
I don't want to pre-screen people. Obviously, in my mind, as I said, if you have a 2000 Honda, it does make a difference. If that car is almost totaled, you have no diminished value, and it would be improper for me to encourage somebody to say, "Oh yeah, let's bring suit." I wouldn't do that.
Okay.
So, as I say, barring some very, very special circumstance, everybody should call me.
Okay. And I thank you for that. And now, as the individual is looking to call you and thinking about their claim, what recommendations would you have? And we're talking about the property damage claim here. They're considering calling you. What steps do you think they should be taking in order to best preserve their property damage or diminished value claim? Is there certain evidence they should be gathering? Is there documents they should be gathering? What would you recommend?
Absolutely. That's a very, very important question. And one of the very first things you should do, and of course, I would say in this day and age, it's reflexive for most people, but if you have an iPhone or something like that, to get pictures of the damage. That is absolutely crucial. It's also helpful because usually, not always, but usually there's a personal injury aspect to it. And you want to take pictures of the scene of the collision at the time so that if a sign gets removed later on or something like that, you have documentary evidence of just exactly what the scene of the crash was, and if there were like temporary warning signs or cones or stuff like that, which are going to be removed at some time, that's very important to record. Mm-hmm. In slower time, and it's not really urgent, but the things that I need to give to our expert is, first of all, the shop report. I mean, we have to know in dollar terms and specifically what parts of the car had to be replaced. Now, sometimes I had somebody with a Hummer that was unique, and they actually could not get all the parts, and that's a very important aspect because some of these niche markets like Hummers, the people know exactly what they want. I had a client call me the other day with a Subaru Forester, and it's an XT, and apparently this is a highly desirable car, and so that when you have a diminished value claim, that is potentially more valuable. So photos of the crash site, shop details, usually, but not always, there is a property claim, and usually, but not always, I get that after the personal injury case has been resolved. Mm-hmm. Now, if the personal injury case has been resolved, it tends to be sort of a no-brainer, like, hey, you paid like $15,000 to repair this car, and so liability is usually not an issue. So, but that's important. If the property damage or personal injury aspect has not been litigated, then again, the person who owns the car has been damaged, and that's another aspect of the case. And occasionally I see that, especially if there's no personal injury. Mm-hmm. But even if there is, once in a while I see that.
Uh, One specific question is there a different statute of limitations on these property damage claims as opposed to personal injury?
Good question. There is. It's 5 years. And, in Virginia, it's kind of funny. If it's this kind of cause of action, it's a year. If it's this cause of action, it's 2. If it's in a decedent's estate or a will settlement, it's really, really a trap for the unwary, even lawyers, to make sure you have the right statute of limitations. But for this particular cause of action, it's 5 years.
Okay. Now let's talk a little bit about court. How long do you think it typically takes for a case to get into court, and what should a client expect when going to court on a case like this?
Well, my practice is mostly, not exclusively, but mostly in Fairfax, Prince William, Alexandria, and Arlington.
Mhm.
I've also been out in Loudoun, and the calendars, the time frames of those jurisdictions are roughly similar.
Mhm.
So once everything has gotten together, and of course, I like to have all my ducks in a row before I file suit. Once I file suit, at least in the General District Court, which has a limit on its damages at $25,000, usually that's a sufficient amount. I'm going to have to see about the rolls. That's a different issue.
Yeah.
But normally I file in General District Court, and you file the papers, and they get served, and then you have what's called a first return, and that is when counsel meet and agree on a trial date. And there are procedural things. It's called a bill of particulars in Virginia. It's the equivalent of a complaint. It's saying these are the facts upon which I'm relying in support of my case. And the defendant files an answer and grounds of defense, which, as its name suggests, we don't think we owe you any money, and for the following reasons.
Mhm.
And then you have a trial. If you have a trial result that is not acceptable to your client, there's an automatic right of appeal to circuit court, and it's what we call de novo. In other words, it's like the General District Court trial never existed. We're looking at this brand new. Now, that's not exactly so, but it is generally so. The pleadings are still the pleadings, and the pleadings are statements made by the plaintiff and the defendant, so that if, and I can't imagine how this would be, but if it would occur in circuit court that there was a disparity between the General District Court pleadings and the circuit court pleadings, that would be an evidentiary problem for whichever party had that disparity.
Mhm. Now, you mentioned expert a little bit a moment ago. Do these trials typically involve expert witnesses, and talk about the money it costs to litigate a case all the way through?
Well, to answer your question like a lawyer, of course, you say, oh, it depends. You ask any lawyer any questions, oh, it depends. And that's true. There is a statute in Virginia, it's 8.01, 418, 419, that says you can use an affidavit by a person who is qualified to make that opinion. Either the person is an automobile repair person or something like that.
Mhm.
And that's a specific statute that you can use. There's also a general statute in Virginia that says anybody can be qualified as an expert if by education, experience, training, previous employment, that sort of thing, is able to educate the judge. That's basically what it comes down to. And I personally have never had a case that I did not have a live witness.
Mhm.
This is my personal opinion, but I think it just is not a good match when you have a live witness and he says, this is what I did, and he has a resume that's a mile long and things like that. I just think it is so much more effective, so that I personally would not normally recommend going with an affidavit. You can, And a good friend of mine actually did, who was representing a plaintiff. But I wouldn't do that. Now, the cost is, well, it's based on the expert's fee scale. I happen to use one that I've used for a number of years, and he's a very good witness. I mean, he's been in 50 or 100, many trials. He's qualified in Arlington, Loudoun, Fairfax. I mean, no trouble qualifying him as an expert. He's had sales experience. He's had repair experience, like body and fender and transmission and stuff like that. He's had painting experience. So this guy knows what he's talking about, not from reading books, but from actually doing it.
Mm-hmm.
And again, it simply adds to the credibility if the person says, oh yeah, or I've been selling this brand of car. I work at a dealership and I've been selling this brand of car for 15 years. And I know what the market is in this area, because it is a fact that the market can be different in different locations throughout the country. For instance, a convertible would sell better in California than, let's say, New Hampshire, simply because the weather is nicer there.
Mm-hmm.
Whereas like a Hummer or some, four-wheel all-terrain vehicle or something like that would probably sell really well in places where people go off-road and in snow and stuff like that. So these are factors that affect the diminished value of a particular vehicle.
Mm-hmm. Let's talk about insurance for a moment. So a lot of what I do in my personal injury practice, I'm talking to people about liability, UIM, MedPay, all that. When it comes to property damage, what kind of coverage are you recommending people get? And talk about gap insurance specifically. Explain what that is and how that works as well. So.
Okay, I'll answer those in reverse.
Okay.
Gap insurance is really important if you buy a new car. And what it provides is coverage for the difference between the balance of your note, assuming you bought the car on time, and the fair market value of the car as the time of the collision. And it may not be right, but it is so that when you drive off the lot, that car depreciates. And I've had a couple of cases where, within just a couple of months after having bought the car, a person gets in a crash. Now, thankfully, it's not a total, but it can be, in which case the insurance carrier says, your insurance carrier says, okay, here's a check for the fair market value of your car. And you say, well, wait a minute, this is not even close to what I owe. And the carrier says, well, this is what we're going to pay you because this is what the law says. And this is what you're entitled to because that's the fair market value of the car. And, this can have a very, very substantial effect on your finances if you are, if you're stuck in that situation. Mm-hmm. Now, as far as property damage, I would say, first of all, I have $200,000 in property damage. This is me personally. Mm-hmm. As an aside, and I realize it's not exactly in this topic, but MedPay is very important. And I can't tell you the heartache that I've experienced with people who had inadequate health insurance. Mm-hmm. Because you have like people from Maryland, they have this PIP, and that gives you like $2,500 or $5,000. You can go through that in the ER. Mm-hmm. And so my MedPay is $100,000. Mm-hmm. And knock wood, I've never had to call on it, but I've seen enough cases where the medical bills do, run up, and sometimes you're not entitled to relief through the courts, and sometimes you are, but that's something that if you have to rely on chance, that's a very, very bad way to go.
Mm-hmm.
And also, of course, when you have MedPay insurance, that gets paid out as you incur the bills, whereas it is not required. And I don't know about most, but many carriers won't pay up until the end, because especially if liability is in question, they say, huh, we're not going to pay a nickel, nothing, until this case is resolved. And of course, you're in the hospital and you're incurring bills and stuff like that. And it's a very tense, very uncomfortable situation when you have these hospital bills piling up. It just is. And it's cheap in comparison with, what you stand to lose if you don't have it.
Yeah, and I'm constantly preaching to people: use your health insurance, buy health insurance, use your health insurance, get MedPay, get UIM. So I appreciate the insight on the property damage and the MedPay as well. So, how does when you're litigating the property damage cases and attorney's fees, how does the statute work on that? How's the client paying attorney's fees? How does that come out of the ultimate case?
Well, it depends. There is a statute that I've used successfully. It's 8.0166.1 in the Code of Virginia. And it says if the amount in controversy is $3,500 or less, and the court finds as a fact that the defense group, the carrier, the attorney, all that, we're jerking you around, we're not dealing with you in good faith, then you're entitled to double damages and attorney's fees and expenses and costs. In the ordinary course of events, in the absence of that statute, each party pays his or her own attorney's fees, and you have to pay the expert. Again, the plaintiff has to pay the expert. And I'm going to say I can't remember any case that I've had where the defense did not have a live expert. That's just an unwise decision to not have a live expert, because you never can tell. Questions arise that didn't come up in the affidavit or something like that. It's just not a good idea.
Okay.
In the absence of that statute, as I say, each party pays his expenses and costs and attorney's fees and stuff like that. There's a process under this particular statute to claim attorney's fees. And basically what you do, if you've been keeping track contemporaneously of time spent, you file an affidavit, and you say, well, this is the amount of time I spent. My usual and customary hourly rate is so-and-so, and these are the expenses that I incurred. And that's the way. Now, it's always a good idea, not required, but it's a good idea to have another attorney say, yeah, I reviewed the stuff that Thyden did, and what he did was reasonable. It was not excessive. He wasn't running the meter, and his hourly rate is within a band of reasonableness, considering the amount of time he's been in practice, the difficulty of the case. Sometimes these cases are very hard fought. I mean, it's just amazing. You see these people, going hammer and tongs for $4,000 or $5,000, and it's just the nature of the beast.
Yeah. Okay. That's a very useful answer. And what was the statute again you were referring to?
8.0166.1.
8.0166.1. Okay, thank you. Now you mentioned Rolls Royces and those kinds of cars. What about for the guy that can't quite avoid the Rolls Royce, but he buys a nice Toyota and then he soups it up? He's got a body kit on there. He's got fancy lights and all these extra things. adding up to, they can get up to tens of thousands of dollars. How does that work in a diminished value claim? What's the best chances for them to recoup that money they ended up putting into their car?
Well, again, this is a matter of opinion, and you have to get somebody who is in the automotive sales field to say, yeah, that car really is super special, and the fair market value of that car is so and so. Now, if the car is totaled, I think you're probably going to be out of luck. They're going to say, look, this is a 2017 Toyota Freelander or whatever, and this is what the Blue Book says, this is what we'll pay you. I think that would be very difficult. On the other hand, for a diminished value case, then you might be able to have a little latitude. Again, it depends upon whether or not the crash harmed the special equipment that you have on the car. With good luck, you put stuff on the back end and the crash hit the front end of the car. But it's very difficult. Luckily, I've never had one of those situations where you have a custom car.
Okay.
But, DV will go certainly for a normal, like Ford, Chevy, Toyota, Honda. I would say certainly 5 years, 2017 or newer, you have no problem. Now, that's not to say that if you have like a Rolls Royce or a Lamborghini or a classic Mercedes, you can have that car be 10 years old and still have very substantial diminished value. So it's not like a bright line where if it's older than this, no. It's usually, it really is dependent upon what the fair market value of the car is. And some of these cars hold their value for a long, long time. I'm not talking about Rolls Royces. I'm like Volvo is a car that holds its value for a long time. Honda also, but of course it's a less expensive car.
I have a Toyota for a reason. So let's get a little more practical for the individual that cars in the tow lot. And you may not have an answer to this, but I have a lot of clients that have a lot of complaints about local tow lots and things like that. What just practical tips do you have for working with tow lots to try to get access to your car, to take photographs, to preserve evidence, to make sure you're not incurring fees, things like that? Do you have any, based on your experience, any tricks of the trade that you would like to share with us?
I'm not sure I understand that question. Are you saying how do I get basically a private investigator or evidence, or how do you gather evidence?
I just have a lot of people that call me and they tell me they're having a problem with the tow lot. Either the people aren't working with them, they're not letting them get access to the car, or they're charging a bunch of fees, and they're just being rude, those kinds of things.
Yeah. Well, that's a very touchy issue. There are statutes that govern that and local ordinances, but that's a real problem. I'm not sure if a tow lot operator can keep you from recovering your personal property from inside that car. That would be something that I would be pretty interested in if I had a client who that happened to. By the way, that triggers a memory thing of mine. It's a very good idea to take pictures of the inside of the car, because sometimes, because of construction of the car, the kinetic energy is directly and largely transferred to the car itself, so that because of the fender and bumper construction, it doesn't look very damaged. But you look inside and everything is, all thrown around. That's a very persuasive piece of evidence that you can show the court. Look at how, heavily damaged my car was. It doesn't look like it. And by the way, if my stuff was thrown around like that, imagine how I was thrown around.
Yeah, yeah, yeah.
So that's a very important thing to remember.
So, John, I've got a point. Is there anything that I haven't asked you that you think that people watching this video need to know, or you want to reiterate when it comes to their property damage claims, and making sure that they're putting their best foot forward to maximize the value of their claim?
Well, I will take liberties with that question.
Feel free.
And I will say one thing that absolutely frightens me is to see, usually it's a housewife or homemaker with a couple, 3 kids in an SUV on a cell phone.
Mm.
Now, aside from the fact that it's unlawful most places, that is so dangerous. That is so dangerous. I mean, distracted driving is one of the curses that we have to put up with. I had a case, lady had a small car, Toyota, Honda, something like that. And there was a woman in a Chevy Suburban, which is the largest passenger chassis Chevy makes. She was on a cell phone call with her brother. Mm-hmm. She ran 2 sets of red lights and hit my client's car, bam, right in the driver's door. That is so dangerous. And it really is not relevant. Oh, I had a Bluetooth and I was able to do this hands-free. It is not the fact of you're physically holding the cell phone. It's that your mind is on the conversation instead of what it should be on, which is driving the car. Mm-hmm. That's one thing that really bothers me. Mm-hmm. And the second thing, and this is sort of a style question, but if I'm in a parking lot, personally, I would rather back into an empty space as opposed to backing into the stream of traffic. Mm-hmm. And I can't understand, except people maybe have not thought about it, why you would head into a parking space instead of back in. Because unless you have one of those cameras, that shows what's happening all around, you just have no way of knowing. And, if there's a car on either side of you, you won't have much of a way of knowing of what's going on until you're substantially backed out of that parking space. That's a particular grievance of mine. Yeah. I will say it is very important that you have adequate insurance. This is sort of after the fact and all that sort of stuff. But if you're not adequately insured, it's tragically so easy to cause a lot of damage, property damage and personal injury. Mm-hmm. And I look at it sort of 2 ways. I look at liability insurance protecting me from inconvenience like garnishing my property or my bank account or stuff like that. But it's also for the benefit of the other driver whom I might injure by my negligence. Now, thankfully, I've been driving for a long time, and to the best of my knowledge, I've never caused anybody personal injury of any magnitude, that would be very serious. Mm-hmm. But this is a very important topic, and it's unfortunate that a lot of insurance agents will sort of poop. Oh no, you don't need that. You don't need that. And of course, if it comes down to either eating or paying your mortgage or buying high coverage liability insurance, obviously that's a different situation. You're forced by the economics to get the cheapest policy you can get. But if you have any discretion, gosh, that is just an unwise decision to skimp on your insurance. Drive carefully. Don't get into crashes. Be observant. I will tell you an incident I had. This was in Maryland. I was at a 4-way intersection with 4 lanes going in each direction, and my light turned green. But as I looked to my left, the curb lane was just bumper to bumper, and I couldn't see any car on the inside lane. And I said, this is where I'm going to tippy-toe out. So I'm tippy-toeing out. As I'm doing that, some kid, this was a BMW or something like that, man, he was going like 45 miles an hour. And the car to my right happened to be a lady, doctor. She just said, oh, the light's green, I'm going to go. And he struck her in the left rear quarter, turned that Mercedes 180 degrees. So, this again is sort of a common sense. It's also a statement of the law in Virginia that a green light does not mean go. It gives you permission if it is safe. So the law is a little bit different in Maryland, but, don't just say, oh, the light's green, go. And sometimes, like if the geometry is such, like a bridge abutment or an overpass or something like that, that you can't clearly see the traffic both to your right and your left, that should, ring a little bell in your head, like, don't just race out into that. Take 2 or 3 seconds. Hey, it might save your life. So that's my speech on good citizenship.
Well, my dad, when he was still a practicing doctor, he was a forensic pathologist, essentially a coroner, and he used to say, you may be right at that intersection technically, but you'll be dead right. So he always said, look both ways, be super careful. Yeah. And I think that was well advised. And as far as the insurance comment, I mean, I'm constantly railing against insurance companies. They tell you you're fully insured. Instead of selling you the $1 million policy, they'll sell you the $30,000 policy and save you a whole $200 a year. So I can't stand that, and I think that's insurance malpractice for these agents to be lowballing you on coverage.
That's exactly right. And most insurance carriers have websites with little Dropbox, and you can see what the differential in the premium is between adequate insurance and inadequate. And that gives you enough information to say, is that wise for me to skimp just a few dollars if I can double my coverage?
Yeah.
This is America.
My suspicion is that people that say they can't afford it, you probably can. You're just not looking at your budget right. But obviously, that's not everybody, but I think a vast majority. Yeah. Okay, so I think that's all the questions I have. It's been super useful. I really appreciate it. Appreciate you again jumping back on here so we could see that beautiful face of yours a little bit better this time. But John, I appreciate it. For anybody watching this, again, John is my go-to guy for property damage claims. If you're calling me about a personal injury case and you've got any questions about your property damage, I'm sending you right over. I think John, a couple of people already called you, and the feedback was very positive. So feel free to let me know if you have any questions. But everybody, I will get John's information up on the screen for you, put it in the show notes and all that, so you can get his name, website, and contact direct information. So John, thanks again. Appreciate it. And we'll have you on again at some point. Okay.
Thank you for having me on.
Okay.